Hello everyone. Today let's discuss one of the interesting and important case coming before Allahabad High Court in the case of Patanjali Ayurvedic Limited. Two important questions are being answered and held by Honorable Allahabad High Court. First, whether conclusion of proceedings under Section 73 and 74 can be considered as conclusion of proceedings for penalty under Section 122 of CGST Act is the first question. Second question, for determining any penalty for offences, 21 offences under Section 122, whether any proceedings needs to be concluded under Section 132, which is prosecution proceedings, whether adjudicating officer, proper officer can adjudicate, pass the penalty order, or it has to go through a criminal proceedings under Section 132 to 138 of CGST Act. Important one. Before I say what is being held by Honorable Allahabad High Court, let's listen to this part. Let me give you a glance of certain provision. If you go to Section 75, subsection 13, it clearly says if penalty is being levied under Section 73 and 74, then no penalty can be levied under any other provisions of GST law. Second, the explanation. 1. Roman 1. After Section 73 and 74, these two explanations are very important. First, Roman 1. Notice or proceedings which is being initiated under Section 73 or 74 does not include any proceedings under Section 132 of prosecution. So these are two separate proceedings, meaning thereby department can initiate both simultaneously. It's alarming position. Just take note of it. Second, explanation 1, Roman 2, very clearly saying that any notice for the same proceeding to the main person, i.e. main noticee, for demanding the tax amount, if it gets concluded, then it should be deemed concluded for any penalty proceedings under Section 122, 125. 129 and 130 got omitted from 1st January 2022. So meaning thereby, if proceedings against main noticee gets concluded under Section 73 or 74, it means for the same proceedings under 120, 122 and 125, penalty shall be deemed concluded for all other persons. So for co-noticee, if there's any penalty, that shall be deemed as concluded. This is what explanation 1, Roman 2. Interesting. But you must listen to this video carefully. Now what happened in this Patanjali Ayurved Limited is, this company has 3 manufacturing units in Uttaranchal, Haryana and Maharashtra. There was DGGI investigation pertaining to wrongful availment of credit and circular trading. SCN was issued to the main noticee, Patanjali Ayurvedic Limited, Uttaranchal. And there was a demand of IGST liability of 9.03 crores. Alongside, there was penalty for certain offences for circular trading under Section 122, subsection 1, Roman 2. Issuance of invoice without supply of goods or services, Roman 7, when you are availing credit on any such invoice or utilizing the credit. So there was a demand under Section 74 to the tune of 9 crore, but the penalty which was demanded for different and separate offense. As I said, 122, 1, Roman 2 and Roman 7 is an important one. So circular trading, issuance of invoice without supply of goods and services, correspondingly wrongly availed credit or utilized credit. What happened? So the demand proceedings under Section 74 got dropped. It was dropped by the adjudicating authority. So once it is being dropped, petitioner has filed a writ petition for all the penalty which was at least what to be levied under Section 122, subsection 1, Roman 2 and Roman 7 for circular trading and wrongly availed credit or utilized credit. What they argued before the court was, if my demand is getting concluded under 74, then quite obvious my all of the proceedings must get dropped. They have relied on explanation 1, Roman 2. And second point which they have argued, that the penalty is supposed to be levied under Section 122, can't be levied unless a prosecution proceeding gets concluded under Section 132. And it is only after criminal proceedings. So adjudicating authority is not a proper officer for confirming penalty or alleging penalty. So these were the two important issues in this particular case. What is being held? First point, conclusion of proceedings under 74. So conclusion of proceedings under 74, ipso facto does not await proceedings for penalty under Section 122. And quite obvious, in this case, there was a particular demand of 9 crore, which is on account of non-payment of tax, but the penalty was for certain specified other offences. That is, circular trading, etc. So 122 subsection 1, Roman 2, 122 subsection 1, Roman 7, wrongly availment of credit and utilized credit. So penalty was alleged for different and separate offences, which is separate with respect to the demand alleged in 74. So in a given case, the Honorable Allahabad High Court has said that just because 74 demand proceedings gets dropped, which was for non-payment of tax, does not mean that your proceedings under 122 for penalty is vacated. So 122 subsection 1 penalty, which is being alleged in a show cause notice, it is for separate offences. And for that penalty proceedings may continue. And that can be decided by proper officer, that is adjudicating officer, and it need not require to go through criminal proceedings as pleaded by the petitioner under Section 132 to 138. So penalty under Section 122 is independent, and that can be levied if it is for separate offense. Now, one or two important aspects. Let me give you as a final outcome. First, it is for the same offense. Let's assume 73, 74 proceedings got started. And for that, 122 penalty is also being alleged. Then there should not be double jeopardy. No double taxation, no double penalty. And that is what we are getting a clarity. When we are reading section 74, subsection 13, that penalty under section 73, 74, it is if it is confirmed, then penalty under any other section cannot be levied. Section 70, 75, subsection 13. But difference in this case was penalty under 74 was for non-payment of tax, but penalty for 122, subsection 1, Roman 2, and Roman 7, it is for circular trading and wrongly availment of credit. Separate offenses. Hence this judgment is coming out that even though demand gets dropped under 74, it is not giving you relief for penalty proceedings under 122. The first one we need to understand, and that is what we need to be careful about. Second part, any notice under 73, 74 does not include proceedings under 132 prosecution. So these are separate proceedings and can continue simultaneously. So alarming one. Third one, explanation 1, Roman 2 for same proceedings to the main notice A under 73, 74 gets concluded. Then penalty for all other persons for the same proceedings shall be deemed to be concluded. That is what explanation 1, Roman 2, that is what it shall be deemed concluded. So there should be a double jeopardy. So Honorable Allahabad High Court judgment, they have created distinction. They are saying when 74 demand is dropped, that is for non-payment of tax, but penalty what is being asked under 122, subsection 1, Roman 2 and 7, which is a separate offense like circular trading and invoice without supply of goods and wrongly availment of credit or utilization of credit. It's a separate, it is separate. So hence you will not get the relief. So when you look at explanation 1, Roman 2, which is giving after section 74, similar provision exists when you look at section 74, capital A, for fraud and non-fraud cases. And same explanation, that is this provision 74 capital A is now applicable from financial year 24-25 onwards. So this judgment is giving a different perspective, but we need to understand the context and then we can decide what is coming out from judgment. It's worth reading. So that is the reason it's been taken a little longer to explain for the judgment. Hope you got the gist of it. So thanks for watching. Stay tuned. Thank you very much.